Many Chinese companies enter Vietnam with an exciting business plan. They launch products, they appoint distributors, they invest in marketing, they prepare to sell. However, then they discover something very shocking. Their trademark has already been registered by someone else in Vietnam. Unfortunately, this happens more often than many foreign companies realize. Some trademark squatters register only one famous brand. Others are much more sophisticated. They register hundreds of trademarks belonging to overseas companies and waiting for the real owner to enter Vietnamese market. And today, they don't simply sit on those registrations. They actively use them as weapons. We've seen squatters send takedown notices to Shopee, Lazada, and other e-commerce platforms, forcing genuine product offline. Even some threatened distributors demand expensive assignments or request Vietnamese enforcement authority to take action against the brand owners. Imagine spending millions building your brand only to find yourself accused of infringing your own product. Fortunately, Vietnam has recently strengthened its legal framework to combat trademark squatting, giving genuine brand owners much stronger tools to challenge bad faith trademark filings. In the past, proving bad faith was quite difficult. The new regulation makes that task much more practical. Instead of looking at only who filed first, Vietnam's trademark authorities can now look at the applicant overall conduct. The new framework focuses on two common types of trademark squatting. The first scenario is mass filing or trademark hoarding. If someone files dozens or even hundreds of trademark copies from foreign brands far beyond any reasonable business need and cannot indicate a genuine intention to use the marks, the pattern itself may support a finding of bad faith. This is particularly important because many professional squatters are not targeting only your brand. They operate on a business model built on stockpiling trademarks and waiting for the legitimate owners to enter Vietnam. The second scenario is free riding or market blocking. If someone finds a trademark identical or confusingly similar to a brand that is already recognized by relevant consumers in Vietnam or well-known overseas with the purpose of exploiting its reputation, blocking your market entry and demanding a buyback payment, restricting competition, and otherwise acting contrary to honest commercial practices, that filing may be challenged as having been made in bad faith. This gives genuine brand owners a much stronger legal basis to challenge professional trademark squatters who register mark not to build a business, but to block competitors and profit from someone else's goodwill. But there is an important message that I always want to give to my clients. Trademark opposition and invalidation action in Vietnam are now stronger than before, but they still require time, effort, cost, and substantial evidence. So if you are planning to enter Vietnam, do not wait until product launch. Do not wait until the distributor agreement is signed. Do not wait until your marketing campaign begins. The strongest protection is still prevention. File the trademark early. Early filing remains far less expensive than fighting a trademark squatter later. Second, monitor the trademark register. Implement the trademark watching service to identify potentially conflicting applications as early as possible. Detecting a copycat filing during opposition periods often provide a faster and more economical solution than seeking invalidation after registration. Third, preserve your evidence. Maintain comprehensive records demonstrating the development and reputation of your brand, including trademark registration in other countries, advertising and promotional activity, sales figure, participation in international exhibition, media coverage, distributor communication, and evidence of commercial activities directed towards the Vietnamese market. This evidence becomes particularly valuable where there is a reason to believe a distributor or a business partner or supplier or other party with prior knowledge of your brand has attempted to register the trademark without authorization. A well-documented chronology of your commercial relationship may provide compelling evidence that the application will file in bad faith. Ultimately, the most effective trademark strategy is still preventive one. File early, monitor continuously, preserve your evidence, and act promptly whenever a suspicious trademark application is identified.